Good morning. Thank you everyone for joining us today as we provide an overview of infrastructure's modernized contracts. I will start with introducing myself. My name is Kathy Maniego. I'm an Assistant Deputy Minister here at Alberta Infrastructure. My portfolio is strategic integration and operations. So my team looks after things like technical standards and procurement, policy, and internal operations. With me is Ghassan El Chazli. He's my co-presenter for today. He's the Assistant Deputy Minister for Capital Projects Delivery Division. Anything you wanted to add, Ghassan, before I jump in?
No, thank you. Welcome everybody to the session. We're looking forward to engaging discussion at the end.
Awesome. So as you can see from the agenda, I'm going to walk through the development methodology, really how we got to where we got and the process we used to get there. I'll talk a little bit about the document organization for our new contracts. Then I'll turn it over to Ghassan to talk about the new elements that you'll see in the new contracts. And then we'll wrap up with our expectations going forward and some Q&A. So our development methodology. The principle we started with is really that risk should be allocated to the party best able to manage it. So with that in mind, this is sort of our high level process. We really looked at how existing contracts and owners allocate risk. We engaged with ILC, which is the Industry Liaison Committee. They support us on a number of issues and we really appreciated all their feedback. We did some further engagement through our industry consultants across Canada with other owners, looking at all of the different contracts that are out there. Then we identified all of our risks, or that we could think of, re-engaged with everyone, and then we looked at aligning the risks with the party in the best position to manage the risk. So this is just a bit of an illustration where we started. We wanted to put all of the information into one place so we could have a quick look at a visual representation of how things were allocated. This is an example of that first step. It was really to review the areas of alignment and misalignment between the allocations of various risks under different forms of existing contracts that are currently in use for all three parties. So province, contractors, and consultants. Again, it's just an illustration. The actual analysis is much more detailed and not exactly as shown, but we just wanted to give you an idea of what it looked like to us. Basically, what you're looking at is, so square in red was where there was no specific risk allocation in the contract that we looked at. In cases where it's red across the whole line, that meant that there was no allocation in the entire contract network allocating the risk. So really that meant that it was unallocated and therefore an unknown risk to all parties. Pardon me. In some cases where you see it mostly green across the line, that was where different parties were allocated the same risk under various forms of the contract. So we had basically parties taking on more risk than they needed to. In other cases where it's different colors across the line, there was substantial disagreement between the contract forms and models as to which party would take on the risk. So as an example, in some cases, the risk was allocated to different parties in the network, depending on the form of contract. And we even had one example, it was toxic and hazardous substances, where contract models allocated the risk to contractors, some to consultants, some to both, and some to all three parties, including the province. So that was definitely something we needed to sort through. So we looked at a lot of different source materials. They were selected from a range of drafting organizations and jurisdictions where similar risks were expected. So, for example, many of the contracts drafted in Ontario were looked at due to the similarities in geography, legal and regulatory structure, industry composition, and procurement methods. We developed new models out of these existing ones with some original drafting with the goal of best expressing the alignment of risk. So again, we focused on risks first and then got to drafting, but we did have all of these different things in the mix as sources to draw from. It was really important to us that we specifically reviewed and considered how other relevant organizations proposed to address the risks so that we could understand where we were already aligned, where we had misalignments, and then we were able to focus on that as where most of our work would need to be focused. So then our next step was to create this giant table. This is literally box one of our risk allocation matrix. This was developed for us to use internally with our internal stakeholders, but also externally for conversations with external stakeholders. The goal was to clearly identify and describe all of the significant risks involved in public construction projects in Alberta. and define those descriptions as necessary, and then provide an avenue for talking to stakeholders, getting perspectives, and then talking about which party should bear the risk. It was an easy at a glance sort of representation that made for conversation. We started with an absolutely giant spreadsheet. It got a little bit bigger. At one point, we had over 100 categories of risk. Over time, those were refined. They were grouped together as best as they could be to make more sense. And then we were able to work at allocating those risks. We obtained feedback from a number of sources. In some cases, we used the risk allocation matrix directly to get that feedback. In some cases, we got feedback verbally or written that didn't specifically use it, but identified the same risks. So then we were able to input that information as well. All of the feedback received was reviewed by the same teams of internal stakeholders, consultants, and executives. So all of us saw all of the same information in making decisions. We appreciate all of the feedback that was provided. It was really, really great to see how many industry stakeholders participated in the discussion, and that was really the foundation for a contract modernization project. The risk allocation development process began early in 2023 and continued through the summer. No actual contract drafting was happening at that time. We didn't start drafting till well after we had discussed most of the risk allocations. There were some, of course, that were looked at and changed over time, as it was a bit of an iterative process on some of the more difficult risks. So working drafts started after the summer last year. So we're coming up on a year now with our drafting. And the contracts themselves will be released and used on projects going forward. They're not all quite finalized, but we are getting there, and you will start to see those come out, which is why we're having this session today. So we recognize that not all stakeholders were in agreement on all items, which is totally fair. Where we were aligned, we did our best to capture those in the contract documents and just moved forward to drafting on those. We did have a lot of discussion on some items. This led to some changes in risk and in terms of the sharing and the allocation. Just as an example, the province has decided to share in the risks of cost escalation on longer term capital contracts, and Ghassan will talk more about that in a bit. As another example, consultants are now going to share in the risks of inaccuracies in reporting that is relied on contractors. So after the risk allocation feedback was obtained, we had some more engagement on some important contracting principles. Some of it, again, was direct, getting written and verbal feedback from ILC and industry associations, which we deeply appreciate. Some of it was more indirect. We reviewed industry publications, contracts, public-facing communications, and then some of it was very targeted. We talked to personal and professional contracts in the industry and in the legal profession, some procurement professionals and academics as well. So all of this engagement led to continual reconsideration and refinement of our models related to the principles identified, and eventually led to our new contracts. So in terms of outcomes, I want to share a little bit of a list of the contract provisions that we've realigned in response to the development methodology. Ghassan will go through some of the new elements in a bit, and some of them, there'll be a little bit of overlap, but I wanted to start here. So in terms of cost escalation, we heard from industry and our consultants that it wasn't always contractors who were in the best position to manage the risks of escalation and supply chain costs, especially on those longer term projects. We learned a lot through the pandemic. We've realigned those risks so that the province would assume certain escalation risks on longer term projects. And then we'll give you more detail when Ghassan goes through that later in the presentation. Arbitration, we heard extensive industry feedback that the removal of arbitration as the main dispute resolution mechanism under the contract was problematic. Our consultants agreed. So we've developed a new modernized dispute resolution procedure that reintroduces arbitration as the main form of dispute resolution, along with more procedural guidance that should result in disputes being settled more quickly and with less expenditure of resources. On geotechnical information, we heard significant feedback that it was difficult for the contracting industry to assume the risk of their reliance on inaccurate geotechnical information. We agreed. The contracts now contain express provisions that contractors may rely on the accuracy and completeness of consulting reports to the same extent that the province can. And at the same time, consulting contracts now contain express provisions about the province and contractors relying on the reporting. Please note, however, that we also heard feedback from the consulting industry expressing concern that they couldn't manage the risk of how that that information was interpreted and used, which we also agree with. So contractors then will remain responsible for how they interpret and make use of the consulting information they rely on. Relief events. Feedback from different groups touched on multiple relief event scenarios that were not well understood or not aligned under all the different contract models. The relief event schedule was developed with this feedback in mind. It is more detailed and clearer than before. For extreme weather, we received extensive feedback about weather-related scenarios that prevent project progress and who bears the risk of such scenarios. We developed a clear definition of extreme weather that can be objectively evaluated so that parties can fully understand and predict whether contractors or the province will bear the schedule-related risks of delays due to weather. Force majeure. Emerging from the pandemic, we received feedback about our force majeure definition and noted that it did not squarely address the issue of quarantine restrictions, which hopefully we will never have again. But quarantine restrictions have now been expressly added into the definition of force majeure, and the provisions have been expanded and clarified. Good faith. We noted a lack of alignment between a number of parties and contract models in regards to the meaning and application of the concept of good faith. We added an express definition of good faith that accords with the legal meaning of the term and places clear parameters on what is and is not expected of each party to act in good faith. We also added the express contractual statement that where the province has discretion under the contract, that discretion must also be exercised in good faith. This is not in response to any actual indication or that discretions were not being exercised in good faith, but more of a written codification of a concept that seemed to be understood differently by different parties. So for contract schedules, we noted throughout the development of the process a lot of feedback about how it was often difficult to isolate project-specific risk alignment terms from terms that were generally used and applied in most or all forms of contracts. This led to the development of an organizational concept, separation of contract schedules from articles. This is generally based on a CCDC and RAIC style document organization system, so separating master terms from supplemental conditions. The separation of contract schedules allows key terms that may change from time to time and from project to project, such as cost escalation, to be moved into the schedules and kept apart from other key terms that will remain the same for all projects as contained in the articles. This allows more transparency for project proponents to be able to more easily locate and review important project details like payment procedures, insurance, and bonding requirements and specifications. Construction schedules. Our feedback through the development process also indicated that there was often difficulty understanding the parameters of the construction schedule development process. The whole scheduling process has been completely revised with clear, step-by-step requirements for what a detailed construction schedule requires. The new detailed construction schedule provision includes the method of development, level of detail, submission deadlines and details, formal acceptance by the province, and effective revisions. We did this to provide better clarity around the province's expectations and varying parties' obligations relating to developing and submitting detailed construction schedules, and to reduce a lot of confusion and misalignment of understanding between contractors, consultants, and the province that might cause project delays. Cash flow forecasting. As many members of industry know, we've also been piloting a cash flow forecasting process that will allow both the province and contractors more clarity on anticipated cash flow throughout the life cycle of projects. Cash flow is a very important issue to the province, and we also heard through the contract modernization development process that it is a very important issue to the construction industry as well. We want to encourage better clarity and transparency about cash flows in the construction process, which we hope will support improved stability for all parties involved on the contract chain. Standard of performance. Throughout the development process, we heard significant feedback from members of industry expressing concern that owners were required elevated standards of performance through new contractual provisions that members of industry did not feel comfortable with. We added written clarification about the standard of performance required for contractors and consultants, which is essentially the care, skill, knowledge, and diligence that would normally be provided by an experienced, capable, and prudent contractor or consultant performing similar work for similar projects in the province of Alberta. Adherence to contract documents is still strictly required. However, there's no general expectation of perfect performance or top of industry standards. Mandatory subcontract requirements. We have heard substantial feedback from the subcontracting industry The more is needed to help Alberta adopt and embrace prompt payment principles on public projects. The newly modernized contracts advance prompt payment concepts, including by establishing some mandatory guidelines for subcontracts on the GOA's public projects. Included in these mandatory subcontract requirements are requirements for alignment of risk issues, such as standards, relief events, good faith obligations, and compliance with applicable laws. The mandatory subcontract requirements also prohibit certain subcontract terms that would undermine prompt payment initiatives, such as those that prevent access to statutory protection or insurance, or those that install pay-when-paid payment schemes. The intent of these requirements is to help ensure the long-term stability and viability of skilled labor and trades in Alberta. And for those of you that have been working with us on the prompt payment legislation, our hope is that our contracts will be fully aligned with whatever legislation we may or may not be receiving for prompt payment on government projects. Components and partial acceptance. Feedback was received that indicated a lack of clarity as to how and when work done on a project could be broken into different parts and how completion of those different parts would be achieved. The new contracts introduce and define components, which can be separately advanced, and partial acceptance of the work can be achieved in respect of each component. And then changes. We also received feedback about change procedures being unclear at times under various contract forms and models. We've addressed this with a comprehensive revision of the change procedures and provisions, bringing the relevant provisions together under a unified article and a single schedule, which can be followed in a stepwise fashion whenever changes are made or proposed. The change procedures are also better integrated with associated schedule and payment impacts, addressing the feedback we received that indicated confusion and misalignment of approaches to the impact of changes. In terms of the document organization, we modeled them largely after CCDC, RACI, and Infrastructure Ontario organization principles. So we have the base form, supplemental schedules, and technical specifications. The use of basic master format specs for technical components is preserved. Some concepts from the basic master format sections are realigned into the supplemental schedules. All terms within the contract articles will be standardized. All contracts of the same model will use the same articles setting out the basic terms and conditions. All project-specific provisions will be in the supplemental schedules and technical specifications. We believe this will create efficiencies for both ourselves and for industry. Hopefully that'll be less time required for bidders to review RFP documents and provide greater familiarity on where to find important components. Like concepts are gathered together rather than being scattered. So for example, all bonding requirements will now be gathered into a single schedule rather than being scattered into different BMS sections. So hopefully this is less work and less risk for consultants who no longer need to review and align as many parts of the BMS sections with contract text. So all security requirements will now be developed by the province and located in a single schedule rather than required in the BMS sections. Information from the RFP will have a designated placement within the schedules. Financial terms and conditions will be contained in uniquely identified schedules, no longer located in different places throughout the contract documents. Issues flagged as important through the consultation process were given their own unique schedule for ease of reference. So cost escalation, dispute resolution, insurance, bonding, those are all unique schedules. Technical schedules will be housed primarily in the drawings and specification schedules. Some may be modified slightly, but still follow familiar BMS format and for the most part the same content. Certain BMS sections will no longer be used as they overlapped with the schedules. So to create efficiencies, less development and realignment for consultants, less review and comparison for bidders, and easier use as a reference point for project managers and administrators. With that, I'm going to turn it over to Ghassan.
Thanks, Kathy. So as Kathy has gone through various elements, I'll just try to go through them a little bit more in detail. The first new element that's been introduced is the standard of performance. Owners imposing elevated or unfair standards of performance was also identified as a current issue of concern. The new contracts confirm the ordinary standard of performance is the expectation. That normally provided by an experienced, capable, prudent contractor performing similar work on similar projects. No perfection or high standard are demanded or imposed. As discussed, good faith is an idea that we all agree with in principle, but many different groups placed different interpretations on exactly what that means. Good faith is now clearly defined and applies to all decisions and discretions exercised by the parties, including those sole and absolute discretion provisions. The definition specifically states what good faith does and does not mean. We believe this will significantly reduce needless disputes and rhetoric over whether something was bad faith or good faith, and provide all parties the contractual assurance of the other party that they will not be victimized by dishonesty, misleading behavior, or arbitrary decision making. The last part of the definition of good faith is also important. Good faith does not mean a party must give up their contractual rights or act in another party's best interests. Cost escalation was flagged as an issue of importance to many members of industry. Cost escalation will now be a risk shared by the province. The schedule would either present or allow for a price adjustment formula in accordance with basic guidelines. Again, this risk sharing will only apply on certain projects, generally longer term and more complex projects. Contractors will still need to estimate and price their short-term cost risks. All cost escalation provisions will be based on adjustment formula. In the case of direct fixed stipulated price contracts, such as design bid build contracts, the province will provide the adjustment formula. In the case of construction management contracts, we are inviting the construction manager to propose cost escalation formulae for its major scopes of work. The province will also either set out or approve, as the case may be, the timing for calculation of the adjustments. Generally, this will be at substantial completion. All adjustment formulae will, whether issued by the province during procurement or proposed by the CM, must comply with 4 basic principles. Based on appropriate indices, adjustments must be based on government published indices, such as Statistics Canada indices, that logically relate to the contractor's actual cost exposure. For instance, on a project where major supply chain cost exposures might be concrete, steel, and labor, the indices selected must reflect those specific cost exposures. If more than one index is used, they should be weighted against one another in proportion to the anticipated cost exposure. Indices that do not reflect construction costs will not be used or accepted. For example, the Consumer Price Index. The cost of consumer goods is not a relevant measure of a contractor's construction costs. Second, cost escalation and de-escalation must work both ways. The province will take on risk of unexpected escalation, but must also obtain the benefit of unexpected de-escalation. Third, we anticipate that some inflationary factors may occur due to ordinary and foreseeable market fluctuations. For example, the minimum wage may rise marginally, or the cost of certain products will rise slightly along with transportation fuel costs. Contractors are still expected to anticipate the foreseeable escalation and bid accordingly. Therefore, a lower adjustment threshold must be set. The thresholds will apply in both directions. This protects both parties. The province will not need to provide added compensation for marginal inflation below the lower adjustment threshold, and the contractor will not need to fear losing compensation for marginal deflation below the lower adjustment threshold. Escalation or de-escalation that exceeds the lower adjustment threshold will result in adjustment of the relevant contract pricing to the extent of the exceedance. So in the first of the examples given on the screen, if the index rises 9% and the lower threshold is 2% and the upper threshold is 10%, then there will be a net increase in price of 7%. An upper adjustment threshold also applies, again, in both directions. This will protect both parties from extremely large increases or decreases in price due to extreme cost fluctuations. So in the second example given on the screen, if the index rises 16% and the thresholds are 15 upper and 5% lower, then there will be a net increase in price of 10%. In the third example, it shows how if a downward price fluctuation does not rise to the level of the lower threshold, the price does not change. For further protection of both parties in extreme market situations, there will be a total aggregate cap on all permitted adjustments. so only a maximum of a certain percentage of the total contract price will be at risk in either direction. Another new element, is the dispute resolution. Arbitration was a popular request to be reintegrated into Alberta Infrastructure contracts. The new dispute resolution procedure reintroduces mandatory arbitration for disputes, along with several optional components depending on the project. Early resolution off-ramps are provided. Both parties will also commit to earlier and more transparent disclosure of positions and issues to facilitate earlier resolution either by settlement or by arbitrator's decision. Timelines will be much quicker than before. The province and industry have a shared goal of reducing the frequency and timelines involved in dispute resolution. Everybody wants disputes to resolve and funds to flow sooner. On suitable projects, the province may also include contractual adjudication or complex arbitration, or both. Adjudication under the DRP will be a simple, quick, non-binding review and opinion by a technical expert already appointed by the parties. This option is sometimes called a referee in other contracts. The adjudication opinion will encourage and support resolution, but it will not be a binding decision. It will be used in situations where the technical nature of a project is more likely to benefit from this sort of quick, independent input. Complex arbitration will only be used where the nature of the project is such that high-value complex disputes may require a more fulsome, more court-like process, and there will be a panel of 3 arbitrators, not only one. Otherwise, it will remain much quicker than litigation, with specific timelines and steps, all of which are focused on obtaining a timely and efficient resolution. The new DRP substantially limits what matters can be referred to litigation. In general, it is only for emergency situations where urgent access to the decision maker is necessary to prevent non-economic harm, or where the value of the dispute is low enough that summary procedures, for example, small claims courts or summary applications, will be sufficient to resolve them. The new dispute resolution procedure prioritizes several key principles that our industry and consulting engagement told us were very important to all parties in construction projects. First, transparency. The whole industry benefits when disputes are resolved quickly and fairly. To support that goal, though, parties must be candid and clear about their positions. We heard feedback that too many disputes lingered for months or years simply because there was no way to drill down to the real heart of the disagreement in an efficient manner. The new DRP supports earlier and fairer resolution by requiring all parties to quickly and efficiently define the dispute, gather their evidence, and disclose the particulars of their position to the other party. This allows the other party to fairly consider or reconsider its own position before formal dispute resolution steps proceed, and the parties begin spending important resources. Timeliness. The province supports prompt payment initiatives, including recognizing that everyone benefits when disagreements are solved and money flows promptly. The new DRP supports more timely resolutions by putting specific timelines on the steps to be taken in dispute resolution. We expect that the new procedures will result in much faster resolution of most disputes than would be possible through court-based litigation. Good faith participation. The province is expressly committing to engage in dispute resolution in good faith, as specifically stated in the modernized contracts, and expects the same commitment in return. Parties are expected to continually look for ways to de-escalate disputes, resolve and refine issues, and find off-ramps from lengthy or costly dispute resolution processes. The province will engage in dispute resolution honestly, reasonably, and without capricious or arbitrary conduct, and the province will expect the same in return. In terms of proportionality, our consulting process led us to the shared concern that the principle of proportionality, once thought to be a main strength of arbitration, had been lost over time. The new DRP expressly incorporates and protects proportionality. In short, this simply means that the parties commit to achieving the most expedient resolution possible to any dispute, having regard to the nature of the dispute and its value relative to the total value of the work to be done. Parties should not drag out or delay the resolution of simple matters, nor seek tactical advantages through improper or unnecessary conduct. Arbitrators and other decision makers will be armed with the ability to discourage such conduct. Again, the goal behind all of this is that we want parties to be able to focus on the work rather than needlessly spending resources on dispute resolution. Our development methodology led us to the decision to realign the risks associated with the accuracy and completeness of geotechnical information. Both the province and contractors will be entitled to rely on consultants' reporting for accuracy and completeness, including regarding geotechnical information. Consultants are best able to manage the price risk associated with inaccuracies or incompleteness of geotechnical information. The province expects that consultants retained for a project will understand the use to which their reporting will be put and who will be using it, and that the province and the contractors will be relying on it. Interpretation and application of the reporting will remain a risk of the contractor. Contractors are responsible for means and methods of construction, so they are the parties best able to manage and price the risk of how that information will be used to inform their means and methods. In terms of relief events, as mentioned before, our process demonstrates there was a lot of misalignment between forms and models of contracts and an understanding of various parties about what relief events should or should not include. This was creating confusion. Relief events are now given a dedicated schedule, which has been expanded and clarified from prior contractual language. The articles now set out process and procedure in the event of a relief event. The designated change in law provisions are also clarified and specifically defined. The definition is also broader than before and expressly includes things like quarantine restrictions, changes to environmental management requirements, and changes to regulatory requirements. Force majeure has been revised significantly to provide scheduled relief for new issues of concern, such as quarantine restrictions and extreme weather. Obviously, the issue of quarantine restrictions was fresh in everyone's mind throughout the development process, and so epidemic, pandemic, and quarantine restrictions are all included in the definition for better certainty. Another new inclusion in force majeure definition is extreme weather. Our consultations, research, and development process led to the conclusion that weather-related impacts were often unclear or not addressed at all in the risk allocation contained within some forms and models of contracts, but they were nevertheless an issue that was very likely to be debated and disputed. We felt it was important to specifically codify and define the province's perspective on extreme weather rather than leaving the point up to debate or discretion. The key elements of extreme weather are prevention of performance, the capacity to objectively evaluate the abnormality of the event using Environment Canada records, and something that could not have reasonably been anticipated at the time of bidding. We also clarified again that the ability to reasonably anticipate weather was not held up to a standard of perfection, just the ordinary standard of performance. Regarding detailed construction schedules, revision to the previous NACP schedule, which many parties consulted felt that was a bit confusing. There's much more clarity on the content and process. A dedicated schedule now explains exactly what content is required on schedules, how they should be developed and aligned with the WBS breakdown, the work breakdown structure, and when they need to be revised. Both WBS and schedule align with the cash flow forecast submitted along with the invoicing. This tracks past and anticipated future billings based on the WBS breakdown and the schedule. We believe this will promote certainty and stability of cash flow for all parties involved in the project, the province, contractors, and subcontractors. The main differences between prior contract forms and the modernized form are not in the form of the schedule, which will remain familiar. The main differences are in the description and clarification of the province's expectations regarding how the schedule is developed and used. The modernized contracts contain example forms these will be familiar to members of industry who already work with Gantt chart style schedules. The contract schedules describing the detailed construction schedules explains how the schedules are to be developed. The schedules start with a construction execution plan developed at the time of bidding. From the construction execution plan, a high-level work breakdown structure must be developed, identifying the major construction activities. The critical path method is then employed to transform the WBS into a baseline schedule, identifying different activity levels. A baseline schedule is submitted and approved by the province. As the work progresses, progress revisions to the baseline schedule will be developed, and if a progress revision is formally approved by the province, it becomes the new operative schedule. The communication between contractors, the province, and consultants about the WBS and detailed construction schedule supports what we heard in development of the project, that more detailed and more transparent communication of important information, such as scheduling, will help to prevent misunderstandings and miscommunications from escalating unnoticed until it becomes too late to address the issue cooperatively. There are some mandatory subcontract requirements. This promotes alignment of important principles through the whole chain of contracts. Examples include good faith, complying with applicable laws, relief events and force majeure issues, and safety requirements. We believe this will not only benefit subcontractors and tradespeople, but also make the subcontracting process more efficient and consistent. There are also prohibitions on certain subcontract provisions. Examples include pay when paid, limitations on accessing security, or reassigning prime contractor status. These requirements also serve important policy initiatives of the government of Alberta. For example, prompt payment by harmonizing uniform pricing and payment procedures, preventing pay when paid schemes, and equalizing access to security, the government of Alberta intends to promote the fair and efficient flow of funds all the way down the contract chain to ensure a healthy construction industry top to bottom in Alberta. Components of work supporting partial acceptance for each component are also a new feature. This supports what we found during development of the project. There was a lot of support for consistently identifying and describing the mechanisms that allow work to be completed in stages and for rights and payments to flow following such completion. And I'll hand it back to Kathy.
Thank you, Ghassan. We'll take a minute here just to outline our very high expectations for our new contracts. We're going to be tracking these expectations and of course tracking our contracts and how things are doing over the next few years as part of our commitment to continuous improvement and positive future transformation. We fully expect that things will happen. We will get feedback. We encourage feedback on our contracts and RFPs. If you have comments on a live RFP, please, of course, use the typical process for that through procurement. But if it's a general comment, we do want to hear those as we go forward and as we start to use these. All that said, we do expect to see all of our contracts, all of the models moving forward to follow these basic forms and changes. But we expect to see more involvement and communication from all parties during project planning, design, scheduling, all that upfront work. We're expecting to be more collaborative. That's our hope. And so hopefully you'll see the same thing. And we expect to see fewer unexpected issues, delays, disputes that arise as we get towards project completion. We're expecting issues and disputes to be resolved more quickly and that disputed funds will be released earlier. That is really a principle that we work towards, so we're hoping to see that. We're expecting subcontractors and tradespeople to be paid on a more regular and more timely basis. This is entirely consistent with the prompt payment principles that we're looking at with Service Alberta, so we're hoping to see that. And we expect communications, like I said, to be more open, transparent, and more direct between province consultants and contractors working closely together, really that collaborative work together on our projects. We are hoping to see more bidders be able to participate in the market with more assurances regarding cost escalation protection, quicker identification and resolution of issues, and hopefully more predictable cash flow. And then as industry, you can expect that all decisions and discretion of the province will be exercised in good faith and with transparency and clear communication. So with that is the end of our presentation. I think we're going to jump into questions. We have a few already. Gassan, do you have one lined up or do you want me to go first?
No, I can go ahead. I'll read out the question first. There's a question, have the contracts been written by justice or by a third party? So the province cannot comment on who drafts its contracts, as that information is privileged.
We have another question about how many pages is the new prime consultant contract. I don't know off the top of my head, but we know that it is, the size is consistent and fits with the size of the other template agreements.
Are there specific indices the province would prefer to use for evaluation of cost escalation? I would say that the most appropriate indices would depend on the project and its major components. Contractors can always submit suggestions for different indices during bidding, and construction managers can propose the most appropriate indices during subcontracting.
Really quick, easy one for me. Is this recording going to be available? Yes, it will. It will be posted by the end of the month on alberta.ca. I can ask another one here. Is industry able to rely on information that is provided by the province or by its consultants? So information provided by the province and used by industry, such as geotechnical information, is intended to be relied upon by contractors, with the caveat that the use of the information provided is subject to the contractors reviewing that information with industry standard of care, and is subject to that contractor's interpretation and application of the information. This is also subject to the province's own ability to rely on the information.
I'll take on a very specific one. It says, how will the existing contamination be addressed in the new contract forms? That's very specific. I will address that in writing after the session.
Okay, so I'm going to address the prompt payment question. So there's a question, will Alberta Infrastructure also follow prompt payment timelines under these new contract forms? So there are payment timelines required of the province under these contracts. Any association with potential future prompt payment legislation, obviously we will follow any legislation that comes in. Our analysis indicated that the province is already a very prompt payer of any undisputed amounts, so we will continue that, and we will adjust if we need to, if and when we get new legislation on prompt payment timelines.
How are risks within contracts delineated between the responsibility of the province versus industry for things such as site due diligence, compliance with provincial procurement policies and guidelines, permitting an owner loaned or procured equipment to contractors? I'll say that the province is focused on allocating risk to the party that is best positioned to manage it and minimize the risk. If it is a risk in which the construction industry is not able or not in a position to manage, the intent of the contract is not to unnecessarily allocate risk to the industry. Where it is a risk that industry is best positioned to and able to manage, it should be industry responsibility.
That's awesome. Gassan, I'm going to propose we just take a really quick 5-minute break. That'll give us a quick chance to, for one, for industry to ask us any more questions, and two, for us to just have a quick look at some of these and make sure we have answers ready to go. Okay, I'm going to answer another one, if that's okay. We have a question here. Who is responsible for the risks to projects posed by weather? So essentially, the province assumes risk of extreme weather as defined in the contract. There's an objective standard provided based on Environment Canada records, and also a requirement to reasonably anticipate weather impacts, exercising the standard of performance.
There was a question about when to expect the prime consultant contract to be used. So we're utilizing the various forms of contracts as various models of delivery are being utilized for the contracts that we're deploying. I don't have a firm date on when the first prime consultant agreement is coming to, or I don't have it readily available, but it's going to be within the coming, short little while that you see a prime consulting agreement coming to the market.
There's a question in here. Is there going to be feedback on low bidding selections for contract? To whoever wrote that question, can you help us out a little bit and clarify what you mean by the low bidding selections?
I'll take the next one I just saw. How will the
Perfect.
prohibition against pay when paid operate if the province won't pay for work that was completed but disputed? Does the GC have to fund this payment until dispute is resolved? Well, general contractors should be managing the risks and their own subcontractors. If invoicing from a subcontractor is disputed due to the subcontractor performance, then the general contractor should use its own contract mechanisms to dispute the subcontractor's entitlement. There's a question there about, says, please, what were the top 3 or biggest risk allocation pain points flagged by the industry in this exercise? Throughout the presentation, the majority of the items that we talked about that are new are part and parcel of the biggest pain points. I can't pinpoint which one specifically was the highest or the lowest, but generally speaking, it was around the area of risk allocation, which we've addressed in the modernized components. Top of mind, having been part of those discussions, was the reintroduction of arbitration, for example, the cost escalation on the larger contracts, that meaning the longer term contracts. Those were top 2 of top of mind that I can recall.
I would agree with that assessment, Ghassan. I know my life has been spending lots of time talking about prompt pay as well, which is very live for me. But I would agree with your assessment of the top 3 really.
Why does the province not use CCDC documents? As mentioned before, there's a whole slew of contracts that we looked at, and we explained in this presentation, for which the recording will be posted, of course. The list of contracts that we looked at and the various trends. I think that was a little bit self-explanatory as to why CCDC wasn't particularly used as a starting point. As Kathy mentioned in her notes at the beginning, the focus was to start from the risk allocation agreement or discussions and then start drafting the contracts. No particular contract was utilized as the starting point.
If I could just add to that, we did look at CCDC documents. They're not specifically written for public works projects, so they need changes to adapt to our projects. So they were considered. We didn't use any one base for any of these. They were a good start, a fresh start.
There's a question: is there a project identified to test these Duke adaptations to the contract? Are there certain contract models that don't apply to these modernizations? So we did start. I mean, the Red Deer Hospital has had 2 construction management contracts already on the street. I think both of them closed. So we have identified that as the beginning of deploying those contracts, and the rest of them, as contracts get ready and are finalized and the requirement is there, you'll see them being deployed. And there's an initial slide that Kathy talked about in terms of, are there any contracts that don't apply to these modernizations? No, we apply them to all models, all traditional models that are adopted by the province. That includes design bid build, CM contracts, and another form called architecture contracts. Those are the ones that are being modernized or deployed as we go along.
Maybe I'll take the next one, Ghassan. A little bit of a project management question. So will the province identify at the start of the project what thresholds the province team members have approval to make? In other words, like in terms of change orders or settlement of claims or disputes? That is a great question, but it's a project management question rather than a contract question. So what I would recommend is have that conversation with your project team when the project starts. Those are good questions to ask. I don't know if you wanted to add to that, Ghassan.
Yeah, I mean, the thresholds are not, as Kathy indicated, thresholds are not defined in contract. They're actually internal processes. So that's based on a delegation of authority matrix internally.
So it sounds like a follow-up to the question we just had in terms of it being a project team item. Contractors need to understand upfront what the authorities are going to be from a contractual perspective. I guess from our perspective, it's not, our authorities within the department are not part of the contract. They are a delegated authority that we have in here. So it is more of a conversation with project teams rather than a contracting issue.
And I'll add to that, there's a formal process for any, like the knowledge about who the delegation of authority, what level is authorized to do what. The process is the same. When a change order, for example, is being submitted by a contractor, it doesn't matter what the value of the change order is and who is approving it internally. That's a matter of policy internally. The submission process is the same. The discussions are always going to be with the project team at the project level, regardless of the value, the internal delegation of authority, if that makes sense. There's a question there about other models in question, intending to use collaborative models, alliances, progressive, DB, etc. Right now, I mean, we spent quite a bit of time modernizing the current forms of contract that we've been utilizing traditionally. As to whether we are utilizing any progressive forms, we are incorporating principles from all modern forms of contract, but we are not labeling those as progressive or alliance or any other sort of branding. Obviously, we continually engage with industry through the industry liaison committee to have those discussions. I'll give the example of QBS, qualification-based selection model. After a lot of discussions with ILC, we actually deployed that in the selection of the prime consultant for the Red Deer Hospital. And we continue to evaluate and assess the viability of utilizing those for the benefit of the entire industry.
Just give it a minute for see if there's any more questions. That said, if there are questions after the fact, we're happy to take those as well. And we will, if any other questions come in, we will be posting answers. If there's any that we didn't get a good answer to, we'll be posting those as well. Because I know there was a couple that were a little bit technical for us to answer on the fly. Appreciate all the engagement on that. Appreciate everyone taking the time with us today. Ghassan, any final thoughts?
No, thank you so much for, again, I echo what Kathy was saying. We really appreciate all the questions. We appreciate the attendance, and we're looking forward to continue to work with all our vendors and all our contractors, consultants, etc., to progress the capital deployment for the province. Thank you.
Yes, thank you so much. And yeah, please continue. There's an email address up on the screen. Send us questions and we will answer anything that we didn't get to or that comes in after in writing. So much appreciated. Again, thank you so much for taking the time with us today. And we look forward to continuing to work with you. Thank you.